You're welcome back. This is Newsfile, it's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. And the matter we canvass for you first has to do with former Minister Cece Dapaah's $1 million and many other millions matter, which it appears has been concluded. It appears has been concluded without further probing. But is that the case from what people see from the Attorney General's advice to EOCO? Joining me for that discussion, the Attorney General and Minister for Justice, Godfred Yeboah-Dame. Abraham Amalba is former Director of Legal Affairs, NDC, and he's currently the Director of Conflict Resolution, National Democratic Congress. Dr. Theo Champong is economist and political risk analyst. Obviously, been working also with the CDD, who have issued a statement this morning taking the Attorney General on and the government on for failing to do what was naturally expected of them. So, let's begin with the Attorney General, and I'm sure, Honorable Minister, that you would have seen the statement issued by the CDD. So if you don't mind, we can start from there. And the CDD says, among others, that the idea that unexplained wealth can give rise to a reasonable suspicion or even a presumption of illegality of the source of such wealth is a principle embraced by our Constitution, notably Article 286, Clause 4 of the Constitution. In the chapter on the Code of Conduct for Public Officers, it makes it clear, in the context of the asset declaration regime, that assets of a declarant that are, quote, not reasonably attributable to income, gifts, loan, inheritance, or any other reasonable source shall be deemed to have been acquired in contravention of this Constitution. It is the same principle or presumption that justifies at least a credible investigation into this matter. It is instructive that Mrs. Dapaah refused to complete a statement of income and property from 4 during the OSP investigation. So far, no other agency is known to have asked her to have asked to see Mrs. Dapaah's asset declaration record or appears interested in getting to the bottom of this matter in order to bring it to a satisfactory closure. The action of EOCO in requesting directions from the Attorney General without first acting on the referral from the OSP to initiate its own investigation of the matter seems oddly contrived. Please note that. Seems oddly contrived. You and the EOCO have come together. You have contrived to let Madam Cece Dapaah off, having been provided with a docket containing various exhibits, statements by 20 or so individuals, as well as the bare fact of the quantum of the monies found in the properties associated with Mrs. Dapaah and her spouse. One would have expected EOCO to proceed with its own investigations instead of seeking the AG's legal advice on prosecution at that early pre-investigative stage. I read this last paragraph. CDD Ghana notes with great disappointment that the abrupt or inconclusive manner in which this matter has been ended fits a pattern, note that, it fits a pattern in terms of the Nana Akufo-Addo administration's general attitude and response to scandals and allegations or reported incidents of criminal conduct, corruption, or other financial malfeasance involving persons closely associated with the government or ruling party. Cases and scandals that have been treated in similar inclusive fashion include various galamsey scandals and a host of PPP procurement deals, including the recent SML case. The government has not demonstrated a good faith commitment to working with the responsible agencies to bring any of these cases or scandals to a credible and satisfactory resolution. It appears the government is more interested in exonerating the targets or suspects in these cases than in working with the state's investigative and prosecutorial agencies to resolve these matters in the public interest. How do you answer to these? Hello, Godfrey Dami.
Yes.
Yes, so my question to you is, how do you answer to these? Because they've just sort of summarized the concerns of CSOs and a large sections of the public.
Right. Good morning, Samson. May I wish your listeners a good morning for a good weekend as well. And I think I must first and foremost comment that I'm utterly amazed at this statement issued by the CDD. I mean, I have very good friends there. Every now and then they even send messages to me behind the scenes to maybe give me a pat on the back on some of the things that I do. Of course, when it comes to those things, they did not come out publicly with their praises, but that's been of the way it is fine. And then clearly, we see that this statement did not have regard any of the matters facts on record. The major allegations by CDD are number one, that EOCO did not conduct an inquiry investigation on this one. Even indeed, CDD itself had carefully read the letter that was written by my office and the letter that telling EOCO. CDD would have found that clearly we said on the first that EOCO had prepared a report on their review on the document. So the letter that Teddy wrote at paragraph 3 of the letter, it said, I think, 9. So it says, you stated your letter that upon a review of the document, the officer, the prosecutor, it is not clear which benefit offense to proceed as alleged case of mind on by yours on. You attach a copy of the report on your review of the OS docket to your letter referred to above. So this clearly shows that you conducted a review of the OS work. EOCO conducted investigations into what we had done, and indeed presented a report to us for review. And I'm therefore surprised that CDD will issue a statement at dawn this morning and mislead the entire public that EOCO did not do any work at all. And I think that the integrity of the work done by state institutions must be recognized and upheld. If indeed they did the proper thing, they must be commended. And EOCO is not the first time they're investigating money laundering. They have been investigating money laundering in many matters related to crimes that they are investigating. And so they know what money laundering is. And so when EOCO is found dead, no basis for convicting money laundering, they could have still written U.S. return the docket and state that is not for indicated by you, money laundering. But the state appropriate, which is to seek counsel of the attorney general regarding further directions to take in the matter. And they duly attach a copy of their report on investigations. So to that point must be clarified. And clearly, CDD's statement there is inaccurate and grossly misleading. Secondly, CDD fought the referral by EOCO to my office for advice. And I'm utterly amazed by this. Because indeed, it is actually within the law governing EOCO's mandate, as well as their practice over the years. Since it was established, in fact, even before EOCO was established, the predecessor to EOCO, the special SFO, the serious fraud office at that time. Clearly, I mean, it is customary of all investigative bodies set up under law seek the advice of the Attorney General on any criminal investigations they are conducting. It's not only EOCO which does that. The BNI sometimes seeks our counsel. The Director General of CID regularly seeks advice from us. So I'm surprised that this well-known convention established over maybe even a century since the Office of Attorney General became public, and is now being sought to be questioned by the CDD. I do not find any basis at all for the CDD's letter. The third point is that CDD actually shows clearly that they did not even read what the special prosecutor had put out in the public. CDD also shows clearly that they did not even read what the special prosecutor had written to EOCO following his press release. Now, the letter written by the special prosecutor to EOCO puts the focus of money laundering investigations into proper perspective. It is worthy to state that a careful look at the special prosecutor's work, the conclusions raised by the special prosecutor in both his press release as well as the letter to EOCO, will show that the premises within which the special prosecutor actually invited EOCO to investigate money laundering was very limited. It was actually limited to alleged transfers of funds from the United States of America. And I refer you to the second paragraph of the OSP's letter. I'll read it for the benefit of the public. The OSP's letter is a brief one. It says, in July 2024, that's the very first paragraph, the Office of the Special Prosecutor, OSP, commenced investigations in respect of suspected corruption and corruption-related offenses regarding large cash sums involving Ms. Cece Dapaah, Minister for Sanitation and Water Resources. The second paragraph says, in October 2023, the investigations became transboundary with the involvement of the Federal Bureau of Investigations, FBI of the United States of America, in respect of part of the cash sums that were alleged to have been transported into the jurisdiction from the United States of America. After 7 months of extensive investigations and 4 months of collaborative investigations, it seems to the OSP that the case is largely in the province of suspected money laundering and structuring. So clearly, the OSP indicates that it is specifically in relation to the sums that were alleged to have been transported into Ghana from the United States of America that should be the subject matter or the focus of money laundering investigations. The money laundering investigations clearly is linked to those transfers. And then early on, if we notice, the special prosecutor himself had released a press statement to the public, specifically saying that, yes, they conducted investigations into the financial affairs and assets of former Minister for Sanitation and Water Resources, Cece Dapaah. Then it concluded very significantly in paragraph 2 of the press release that after nearly 7 months of extensive investigation by the OSP and a parallel inquiry by the FBI, no direct and immediate evidence of corruption has been found in the seized funds and frozen bank accounts linked to Ms. Dapaah and her associates. And then they proceeded to say the investigation has identified strong indications of suspected money laundering and structuring. And then, of course, they acknowledged their inability to investigate money laundering by virtue of the law that they were operating with. But they concluded significantly, laying basis again for the investigation into money laundering. It's concluded a portion of the inquiry was entrusted to the FBI due to allegations suggesting involvement of transfer of funds from the United States. So I think that this clearly settles the issue that insofar as the funds located in Madame Cece Dapaah's house were concerned, insofar as even lodgements into her accounts locally were concerned, and insofar as the sums that were seized by the OSP were concerned, There was clearly no direct or immediate evidence of corruption. And that is not me stating this. This is the special prosecutor himself, clearing Madam Cece Dapaah. So the record must reflect the point that the OSP properly seized with the jurisdiction to investigate, or seized with the mandate to investigate corruption and corruption-related offences after conducting an elaborate inquiry, cleared Madam Cece Dapaah of corruption. That's the OSP. So why is the CED now trying to suggest that the Attorney General now has cleared anybody of corruption? EOCO never investigated for corruption. The Attorney General has never investigated for corruption. It is the OSP itself which conducted 7 months of extensive investigations into it and 4 months of what it describes as collaborative investigations with the FBI and came to that conclusion.
All right.
And I'm saying that, so the public must understand clearly that the OSP only gave a narrow remit to EOCO to investigate for money laundering in respect of the funds that were allegedly transferred into the country.
If I may ask, if I may ask a couple of questions for direct answers, as brief as you can.
Yes.
The CDD says this was too early in the day for EOCO to be coming to you for directions. Is that what you do in the normal course? Is that what EOCO does and other agencies that are under you do in the normal course when they are seized with a matter to investigate? That very early in the day, they bring it to you and say, show us a way? So,
first and foremost, it must be placed on record that there's no time frame within which an investigative authority can seek the counsel or advice of the Attorney General. Indeed, even the recent train accident, the importation of the trains into the country, I mean, during the test exercise conducted on the trains, and the accident that occurred. Just within a week after the man had been sent to court, CID brought the docket to the Attorney General for advice. so really, there's no time for that.
Number two.
EOCO did not. No, hold on. EOCO did not refer to us immediately upon receipt of the docket from the US. EOCO actually conducted its review and prepared a full report on it.
Why a review? Why a review instead of investigations? Because this is the area. This is the area the OSP had not done and required the EOCO to investigate. So why a review?
Okay, so we'll come to why. So firstly, the investigation by EOCO will include an assessment of the docket. So I understand the referral by OSP itself to essentially mean a complaint of money laundering. Well, indeed, EOCO had never been seized with the matter. EOCO had never conducted investigations into the matter at all. The only time EOCO came into the matter was when the OSP invited the EOCO to investigate this issue. So that essentially would suggest, I mean, loosely called, that it is a complaint by the OSP. Now, the OSP presented documents in support of that a complaint or referral. EOCO definitely owed a duty to scrutinize the entire docket, which they did. They examined everything on the docket, including statements that had been taken by Madam Cece Dapaah and her husband and other people, including even some journalists. It also investigated bank statements on all the accounts owned not only by Madam Cece Dapaah, but other persons associated with her, including her husband and all. They also investigated all contracts. In fact, it is very important to note that the OSP itself, in exercise of its mandate, which related not only to the bare offense of corruption, but which includes procurement breaches, proceeded to investigate all contracts that had been signed by Madam Cece Dapaah in her capacity as Minister for Sanitation.
So, there
was not a single breach of procurement procedures. There was not a single breach of.
Do I hear you say?
Any criminal violation?
Do I hear you say your advice was on the back of EOCO's investigations and not what OSP had done?
Everything, because EOCO did not just present their report to us for advice. EOCO presented the entire docket on the Cece Dapaah matter, which has been delivered by the OSP to EOCO. And EOCO presented those documents together with their review report to the Attorney General to advise on the way forward.
Right. So the point is that, the substantive point you are making is that EOCO did its job in investigating money laundering and found nothing.
Yes, and found no basis for proceeding. And that is why the EOCO stated in their letter to us that upon a review of the docket and upon preparation of their report, they find no basis to posit an allegation of money laundering. And because of the sensitive nature of the matter, we
go back to upon a review of the docket rather than upon their investigations.
So that investigation again included an inquiry of the special prosecutor. And if you look at the letter we wrote, we alluded to a letter written by EOCO on 1st February 2025. That was long before EOCO presented the docket to us, asking the special prosecutor to present to EOCO its findings on money laundering. Because indeed, the special prosecutor stated clearly that the money laundering allegations were in respect of transfers from other jurisdictions into the jurisdiction of Ghana. And that is pursuant to the collaborative investigation that allegedly the office had carried out with the FBI. And clearly, so EOCO reasonably would be entitled to the findings of that exercise.
So if your advice,
EOCO requested for a copy of that report from the special prosecutor. To date, the special prosecutor has not finished.
So if your advice is based on the EOCO's investigations, why do you say that the OSP's referral was without basis for money laundering? Because OSP alluded to collaborative investigations with the FBI, based on which it came by transfers from other jurisdictions into Ghana. So the OSP in its investigations had noticed some transfers of money from the United States of America into Ghana, not from Ghana to the US. And that clearly will require a proper statement of that record. So EOCO, in pursuance of that, wrote to the OSP asking for a copy of that report. EOCO did not receive any reply. To date, it has not received any reply. And that was way back on 1st February. And today, as I speak to you, it's 4th May, is it not? And that's 3 months. Let me read this portion of your advice under the hand of Evelyn D. Kilson, Chief State Attorney. Even though as part of your mandate, you could commence investigations into the sources of the money found in the home of the suspect, we do not find this necessary. Please, do you hear what you said?
Yeah. And there's a reason why we say we do not find it necessary.
That says the EOCO did no investigations.
No, I'm saying
because you actually say that was not necessary.
Something. I think that it's so trite that it cannot take just one line out of a 3-page letter and conclude in that manner, especially when the letter began with an acknowledgement of the work that had been done by EOCO, the report that had been prepared on the matter by EOCO, and now examination of that report together with other documents on the docket. And I'm saying that line is actually, there's a reason. If we read a full, if we read a line in
the next part of that line,
it will state that
the next part of that line is that you had instructed the police service, who are already seized with other aspects of the case, to investigate the sources of the huge sums of money found in the home of the suspect, a fact the OSP is aware of.
Precisely, and that's the very first thing we do in money laundering.
So EOCO, you are saying that EOCO has come to an end in an investigation, finding there's no money laundering. Is it your expectation that the police will continue with on your instructions that they should investigate money laundering?
I'm saying that two things arise out of that sentence that you read. Number one is the point that, indeed, the CID of the Ghana Police Service had way back last year been directed by the Attorney General to investigate the sources of the funds and other matters connected therewith. And the OSP itself was in our way. If you recall, there were various applications filed by the OSP in the Cece Dapaah matter, and they attached a copy of the Attorney General's advice So indeed, I would expect that the referral should actually have been to the CID and not to EOCO. The referral by the special prosecutor for investigation into money laundering should actually have been to the CID, since he was already aware that the investigating the source of the money. The second point that arises from that sentence is hold on. I think it's very important. Now, the OSP itself having investigated those transfers from the United States of America clearly knew the sources of the money. So even the sources of the money, for me, are known to the OSP, and the public ought to demand from the OSP his indication as to the sources of those monies. Because indeed, the OSP has come up with the conclusion that the transfers to the United States of America, which he came by pursuant to those transboundary investigations with the FBI, clearly the transfers will indicate the sources. So he knew the sources. So I really find even the referral to EOCO unnecessary in the circumstances. Has anybody sought to find out from the special prosecutor what those transfers actually entailed, or who did those transfers and the volumes of those transfers?
A substantive,
I think the issues are quite simple.
A substantive point you make.
The public, if CID is actually concerned, they would actually ask those questions. And you look at CID, they don't even ask the question at all of the special prosecutor as to why they did not even reply to the EOCO's letter. Why they did not cooperate with EOCO.
A substantive point you made in your advice is that the OSP also may be getting things wrong, because for EOCO to be able to prosecute on money laundering, there ought to be a predicate offense.
Yes.
Question: when you asked the police to investigate money laundering, what was the predicate offense for which you were asking the police to investigate money laundering?
Number one, if you look at our letter to the police properly, I mean, and I think that it's very important to acknowledge the efforts of the Office of Attorney General. The state attorneys there are properly trained. State attorneys are people who are skilled in prosecuting money laundering and all that. They do not just jump to the conclusion that somebody or a person is accused of money laundering. No, they don't do that. So they'll first find out from you the source of your money. So nowhere in the letter written by the Attorney General to CID would you find the word money laundering. No, but you first have to ascertain the sources of the money. Do you understand? And that is what the special prosecutor and the CID, with all respect, ought to have done. Indeed, CID is actually still engaged in the exercise. The first point that we made was for them to investigate the sources of the money and all questions that we raised in the letter related thereto. So it's not just the case. You see, the mere fact of discovery of money, either in a bank account or the person's physical premises, does not suggest the commission of a crime. Is there any crime committed by the discovery of money in a person's home? Something.
But when the person,
hold on.
May I answer the question you asked? When the person involved is a public officer,
right,
and the person's source of income is known and cannot amount to the stash of cash sums in excess of $1 million, almost 3 million Ghana cedis, almost another 600,000 US dollars. That is in addition to the money the person says has been stolen by their house help. And for a long period of time, the person is not known to conduct any business that should earn them money.
Right.
You should be interested. You should be interested in how they come by that amount of money.
Absolutely, I'm interested in that, and indeed, I'm one of the proponents for even the setting up of this equivalent of public officers law. I'm actually the one mooting the enactment of the public officers law. It's something that I've been pursuing and all. And the point is that we must recognize that the complaints relating to the loss of money was actually made by Madam Cece Dapaah herself.
That's right.
In her original complaint to the police, she indicated how she even came by the monies in her house. She indicated straight away in her original complaint, at the time that I had not even heard about the matter, at the time that there was no public attention on the matter, when she walked quietly into the police station and made a complaint. Her original complaint indicated that the monies were monies belonging to her late brother that her mother had given to her to keep following the death. It is her original statement.
Right.
Now, so even the person has indicated the source, nonetheless, the principal ought to investigate.
I need to get to my other guests, but I need you to answer this one. This particular one. Imagine, let's take it that the EOCO, in fact, we take your word for it. We have no reason not to believe you. That the EOCO investigated money laundering and found nothing. If they investigated money laundering and found nothing, the EOCO is the same entity that has the mandate under Section 1.3 of the Anti-Money Laundering Act. Is that not so? That section says, once the suspect can't explain the source of the money, the offense is deemed to have been committed.
Again, you're getting totally wrong. That section is still linked with the commission of a predicate offense. It is not in a vacuum. That section still relates to the commission of an offense. So the basis for money laundering has actually been determined in a number of cases in Ghana. Remember the NCA trial, which led to the conviction of Mr. Bafuboni and a few others. Remember? There was a medical doctor who was acquitted of the offense of both stealing and money laundering. The medical doctor who was actually a public officer, I think he was working with a Kulebu teaching hospital also, Dr. Hensel or something. Now, this medical doctor was a member of the NCA board and had possession of about 500,000 United States dollars that they had made some transfers into his account and all that. The medical doctor could not offer any explanation at all as to the source of the money. The Office of the Attorney General charged him with stealing as well as money laundering. Because you cannot just charge money laundering in a vacuum. That is why it's very important that the OHP's exoneration of Madame Cece Dapaah is significant in this whole point. OHP have exonerated Madame Cece Dapaah of corruption and corruption-related offenses, ought to have indicated the specific offense that he thought could be the basis for money laundering. So after the prosecution's case had closed in the NCA matter, the judge found no basis for stealing, the offense of money laundering.
Okay.
Justice Chibafo, and acquitted the medical doctor of stealing. Having acquitted the medical doctor of stealing, Justice Chibafo held the view, rightly, that he ought not even proceed to determine whether there was money laundering at all. Money laundering does not operate in a vacuum. And subsequently proceeded to then acquit the gentleman also of money laundering. So you cannot just proceed on the basis of money laundering in the absence of nothing. That's been clearly decided.
This same EOCO's law allows it to do a lifestyle audit of the individuals who are in public office who may have been found in these circumstances.
In their law, in the EOCO Act says they should conduct lifestyle audits of public officers. There's no provision at all like that. I mean, they can only do so as part of investigations. And I think if we look at all the provisions of the law as a whole, section 1, 2, 3, up to 5, as well as the interpretation section of the Anti-Money Laundering Act, clearly, there's no way a person can investigate another person for money laundering without
okay. All right.
predicate offense.
All right. So please.
So the discovery of the money that the person claims that it came from her brother and all that means that the person has committed money laundering. I think the fundamental question that ought to be asked: what were the specific findings of the OSC in relation to the transfers to the United States of America? And again, if you would note, it means that even the money laundering allegation that is being bandied about by people, we're not even in relation to the monies found in Cece Dapaah's house. As per the OSC's own letter to EOCO, and as per the OSC's first statement,
all right. Thank you.
It was in relation to a transfer from outside
Thank
the
you very
country.
much, Godfred Dami. Now, let me bring in my other guest. Abraham, the presidential candidate of the NDC has gone ahead to say that this matter will be reopened if he wins power, and that there will be an investigation into not only money laundering, but all of these issues surrounding Cece Dapaah. You've heard the Attorney General.
Samson, good morning to your viewers. And let me start by saying that the more I listen to the Attorney General, the more I come to the firm conclusion that this country is finished. The Attorney General's letter to to EOCO, in my view, is despicable, obnoxious, and ridiculous, to say the least. Why am I saying this? Special prosecutor was seized with some facts, and the special prosecutor started some investigations. Along the line, it transferred the matter to EOCO. As we speak, EOCO has its own investigators. You know this. You have written a letter to EOCO stopping an investigation, and you are talking about predicated offense. How do you get an offense if investigations are not conducted?
He confirms this morning that EOCO did its investigation.
No, he said EOCO did a review of the files brought to it by special prosecutor.
And it did its investigations. He's confirmed that.
Are you saying that Cece Dapaah was interrogated by the EOCO? No. Are you saying that?
You don't know that for a fact. He's saying EOCO did investigations, also went into contracts and everything, and
but you just said that
there's no trace to those contracts as far as the monies are concerned.
There's a letter written by the AG said they should stop the investigations. You read the letter going to the EOCO, that in their view, the investigations must be stopped.
It says investigations into money laundering are not necessary.
Yes. So clearly you can see, and I agree with the CDD report, a contrived conduct by the Attorney General, EOCO, to come to this conclusion. Look, Article 2864 is clear, and you've read it from the CDD report, that unexplained wealth can be a source of investigation. Why would the AG think that because the special prosecutor's report shows that they could not establish some offenses, corruption, but the EOCO, which is seized with money laundering, which could have done its own investigation and has investigators, were not also allowed to carry on with their own investigation and then come to the conclusion that this matter has ended. Look, the very moment that the special prosecutor transferred the matter to EOCO, I knew the matter had come to an end. And this is where we are today.
You are talking about the Constitution's injunction for lifestyle audit, so to speak. That if you have money, you are a public officer, you have money, and you have not declared it, or even if you have declared, it's not traceable to a loan, a gift, inheritance, or your earnings. That money would have been said to have been acquired in contravention of the Constitution. He's saying that your issue is about your inability to explain the source of that money. That EOCO's investigation shows that she has explained the source of that money. And in fact, when the $1 million and the rest matter went to the circuit court, it was explained that that money belonged to some sources.
You remember when the matter went to EOCO, she first said that it belongs to the late brother. It turned out that wasn't true. She said it's sources from her boutique, or is it a hairdressing something. It turned out that not to be true. Even in those cases...
How do you say it turns out not to be true?
No, it was established by the EOCO, by a special prosecutor, that they found out that those allegations were not true. Indeed, it is an offense to even, as it were, lie to a public officer. That alone in itself is an offense in itself. Now, you notice that when the Attorney General indicated that because the special prosecutor failed or could not establish corruption, and for that matter, the case was transferred to EOCO, and EOCO also couldn't establish the crime that was committed so as to give rise to money laundering. For me, I felt that was too simplistic, to say the least. That because you could not identify a crime which resulted from, which gave birth to the proceed, that meant that EOCO had no jurisdiction to, had no right to continue.
Shouldn't you rather be asking if EOCO investigated the claim that, is it 800,000 of the $1 million was funeral donations or something? Shouldn't you rather be asking EOCO, what investigations did you do that showed that, in fact, this money has been properly explained, that it is money that came from funeral donations?
But even the letter written to EOCO specified that some amounts could not be explained. Did they allow EOCO to investigate those special amounts? No investigation was done to establish whether those amounts were legally obtained. But you see, I see what is happening as a clear indication of cover up. Ever since this government came into power, and the CDD report has indicated that, you will find that people connected to this government, anytime they are in conflict with the law, you have the Attorney General, you have state institutions coming to protect them. We have the Galamsey matters by, what is his name?
Professor Frimpong Boateng.
Frimpong Boateng, and then also the chairman of the Ashanti region. All these matters are still with the police. What are they doing about it? But could the Attorney General get to the bottom of this matter? He couldn't. Because already the president had cleared the woman. Is it an appointee of the president? Oh, the president said that he was sure that her innocence will be established. At a point when no investigations were conducted.
He would have known the facts that you are getting to know that now that you didn't know.
So the president should prejudice the work of state institutions. What would happen if the president waited for the state institutions to finish their investigations, and then he will now say that I knew that this would have been the outcome?
Dr. Theo Champong, are you satisfied with what you have heard from the AG in explaining their advice, or you have questions for the Attorney General?
Good morning, Samson. In fact, it raises more questions for me than answers, listening to the AG's remarks. Because as you read the latter part of the letter written under the hand of Evelyn D. Kilson, and we must also put it on record that this letter is dated, I think, the 25th of April, 2024. So it's fairly new in that respect. And again, I think it's important to quote it. He says that, quote, even though as part of your mandate you could, it didn't say they did, commence investigations into the sources of the money found in the home of the suspects, we do not find this necessary since this office, before the reference by the USP, had instructed the police service, who are already seized with other aspects of the case, to investigate the sources of the huge sums of money found in the home of the suspects, and it goes on and on. So clearly, from this letter and all the premises that are made before that, it comes across to me that the EOCO has not done fully the investigations that are required, and it's more or less the AG's office trying to stem their hand and trying to tell them that, no, don't go into doing any of the necessary investigations that are there. And this is quite contrary to what the AG has just said on this platform, a few moments ago, because it says that they don't find it necessary. So in essence, don't go and do the investigation. And for me, again, the optics of it is not right, because my worry from all that is happening is that this case may become one of those cases that we see in Ghana. It's a foolish case, right? That it will go back and forth, and we may never see fully the light of day in terms of any substantive convictions or any of those actions that are meant to be taken. Because there's already a certain perception, and you see that in the CDD report, in other reports, that some of the alleged corruption or corrupt cases involving certain appointees of the administration are not being investigated properly, and people are being more or less, let go in that context. And I think this fits into that narrative or that public perception, that is out there. And I also get worried because, again, listening to the AG and other sort of government spokespersons on this, the impression is created that the OSP hasn't done or didn't do a thorough job in their investigations. So in the letter, they make reference to the FBI collaboration and the work that they're doing in trying to prove this particular offense or not. But again, we don't know for sure whether that FBI work has been concluded. And then they also mentioned the fact that the OSP itself did not provide all of the required documentation to EOCO in order to be able to further, do its work. But it all comes down substantively to the point of law. And I'm no lawyer, but what I read basically from the summary of the 3-pager document under the hand of the Chief State Attorney and others is that the crime of money laundering and structuring, more or less, they are struggling to prove that. And I'm just sitting here shaking my head. So even if we cannot prove that, for argument's sake, are there not other offenses within our statutes and codes that we can allow EOCO and other agencies to thoroughly investigate and therefore, bring the matter to its natural conclusion, rather than this attempt from this letter to try to, force or stymie the hand of EOCO into doing what it should be doing?
We understand from the OSP that when the EOCO wrote to return the docket back to them, the letter that accompanied the returning of the docket they had referred to the EOCO had said, among other things, that, quote, in the light of the above, that is the AG's advice, we are unable to commence investigations. They use the word commence investigations, end quote. So this is to challenge what the AG is saying, that EOCO had done its investigations. Yeah, we are trying to get the OSP to speak to us because they have concerns with what the Attorney General is saying and what EOCO has said. So what do you say in the light of this?
It's quite clear, something. It's quite clear on the surface of what you have read. And one does not even need to be a rocket scientist. You read the letter from the Chief State Attorney, and it is very clear that we don't find their investigation necessary because somebody else is doing this and doing that. And for me, again, it does not speak well. The optics don't look good. I
ask Abraham Amali, but maybe same question to you. Do you think that when the Office of Attorney General received the EOCO's review or work, they should have been asking EOCO that if you have investigated, what constitutes the investigation into the explanation to the sums of money, the $1 million, the others, and the extra that the OSP found, and huge sums in bank accounts at a time when the OSP's suggestion was that she didn't have any business that was a going concern, which could bring in those monies.
Yeah, something. And that's true, because if they had done the investigation, we would have at least had some cause or some substance to prove where these sources of monies came from in terms of EOCO's work. And it is quite clear from the documents that we have read and the bits that you've also just referenced that that investigation doesn't seem to have been done. So I kind of worry a bit, when the AG is saying that EOCO did its own investigation. Who did they speak to? Which other sources did they bring in? How did they go about proving the instances of the monies, the bits of that 1 million and others? That's right. All not done.
Doc, thankfully we have the OSP's Director, Strategy, Research and Communication Division Samuel Apiadako joining us. Yes, you have questions to answer. The EOCO that you simply gave your docket to said they wrote to you asking to know about what the FBI you spoke about was doing. You didn't give them anything. They needed further information. You didn't help them. And this is where we are. So you didn't do your job well.
Thank you very much, Samson. First of all, let me state on record that when the OSP made a referral to EOCO, there were standing committees that were supposed to collaborate because we had not entirely washed our hands of the case. So there were two representatives, one from EOCO and one from us. But I also like to put on record that at no point in time has EOCO requested for a copy of the FBI report.
Really?
We need to be very accurate. At no point in time did EOCO request for a copy of the FBI report. But Samson, let me also go ahead to say that even if EOCO had requested for a copy of the FBI report, it was not just going to be that simple that FBI report would have just been given to EOCO. Remember, there are MOUs between OSP and the FBI. And they are also, I'm aware that there are also MOUs between EOCO and FBI. And this particular investigation was in respect of OSP, in respect of corruption.
But you are making a serious claim. The letter says that we observed that by a letter dated 1st February 2024, you wrote to the OSP to furnish you with a copy of the findings on the case to facilitate your investigations. You inform us that to date, the OSP has not responded to your request. Before that, they have said that it is noted, before that they have said that it is noted, however, that the OSP did not present a copy of the report on the collaborative investigations conducted with the FBI to your outfit. Neither are the findings of the transboundary investigations conducted by the OSP stated in the OSP docket to you.
What you've read is very clear, and I've also had the opportunity to read the same thing you are reading from. You notice that in that paragraph that talks about investigative report, and I will come to that, but let's just finish. That paragraph never said that they requested for FBI report. They rather said that they had not seen the FBI report. So we want to make it very clear. EOCO did not request for it. And I'm saying that even if EOCO requested for it, this FBI report has a lot of confidentiality clauses on it that was directed particularly to the special prosecutor. And you can't just give an FBI report to another agency because you have transferred. There ought to be a lot of what I call interagency collaboration and clearance. And so if it had happened, then we may have triggered clearance so that either we are cleared by FBI that, oh, you can send it, or FBI would directly send it to them. The other point I want to make is that the OSP should be taken as a whistleblower to EOCO. So as a whistleblower, we have given EOCO, we gave EOCO platinum information. Ordinarily, you will not even find other agencies give such information to EOCO. And let me tell you exactly what we gave to EOCO. So you notice that Attorney General's office talks about a docket. It's not just a docket. That particular docket has caution statements of suspects and witnesses, about 20 suspects and witnesses in America, in Accra, and in Ashanti region. And these are investigations that we have done that give us the sense that almost everything we have looked at may fall in the realm of money laundering. So it is not just in respect of a transaction in America, but also in respect of the monies, the over 10 million Ghana cedis, if you convert, that we found in Ms. Dapaah's house, and including all the monies we saw passing through her bank account. So our referral is not just in respect of a transaction in America. Also, we were not conducting money laundering investigation. We were conducting corruption investigation. And so we are of the opinion that we had all that it takes to send that referral to EOCO, because on that basis, there is no way we could have proceeded and then investigated and then write a report on money laundering for EOCO. Then EOCO will send to AG. No, we only referred a matter to EOCO as whistleblowers for EOCO to investigate. And that point, I think, ought to be very clear. And we were not under any obligation to have conducted a money laundering investigative report and given it to EOCO. Then what will EOCO do? Because we cannot instruct EOCO as to what they are supposed to do. The fact that the Attorney General directed the police to ascertain the sources of the money exposes as bare the conclusion that the OSP's request for investigations is baseless. If it is baseless, why has the police been directed by the AG to follow the money? The OSP's request to EOCO to do investigation in relation to money laundering is akin to saying EOCO should follow the money and its sources. And this money, we don't mean transactions only in America to Ghana. We mean the entirety of the money we came across. The OSP is not
you have also been
privy to the
informed.
state of affairs.
You have also been informed. You have done all of this. So you have some information that goes to the source of the money or what should constitute the predicate offense on the basis of which they can do a good job. And you are not helping them with that. That's the AG's charge to you.
Isn't that funny? And I'm using the word funny advisedly. EOCO has platinum information. Let me go back to it. The statements that were taken from people in America has details of how they transported the money into Ghana, whether they went through the rightful source or not to bring the money to Ghana. If you are looking for a predicate offense, which I don't share in that law, because if you read the memorandum to Ghana's Anti-Money Laundering Act, it states clearly that money laundering is also an offense on its own. That does not require any predicate offense. And that is why the lawmaker created Section 1.3. So even if a court of law,
but the Attorney General has pointed you to a precedent where the court refused in such a circumstance that you are urging them to do.
That is why we have an appeal. So the state ought to appeal, because then the judge is rewriting the law. Because if all members of parliament come together and in the memorandum to the bill states that the reason why we are including this is to enable us to be able to try money laundering as an offense on its own, particularly when we cannot discover the sources of income. And I'm also trying to say that the docket we gave to EOCO, if you go through it very well, especially the statements we took from suspects and witnesses, you notice that there is every indication for you to be able to follow the money, because these people have stated as to whether Madame Dapaah could have had such monies or not. For instance, we also just did not send them statement. We also added every other relevant information, including some chiefs and people in Madame Dapaah's hometown or so coming to us to say that the monies and the gold and the things we are all talking about is even a family heirloom. This I know that many Ghanaians are not aware. So we are trying to say that we should be looked at as whistleblowers, and that every information EOCO needed to start investigation, the OSP had provided. Sometimes for interagency collaboration, we do not want to muddy the waters. But when we began investigation into this matter, and I'm going to say this with all the caution that I need to do.
Yes, and
sometimes I feel like
that'll be the final point you make. Yeah.
Police, I will give you an example. When we started these investigations and we went to police, up to today, we do not have any docket from the police in respect of even the house helps of Madam Cece Dapaah. Because when we began our investigation, we wanted all those information, including the caution statement of all those maid servants who are standing trial, because we needed all that to be able to do a very good job. But we did not get it. Nonetheless, we proceeded and did our own investigation, and we were able to even recover more monies from Madame Dapaah's house. All that we are saying is that no blame should be laid on the doorstep of OSP as an inability of another agency to do its job because we were not required.
Samuel Appiah
to have
Darko,
investigated for
Director,
that.
Strategy, Research and Communications Division of the OSP. Thank you very much for your time. Do I still have the Attorney General on the line? All right. Okay, so this is where we will draw the curtains on this subject matter because obviously this will continue to attract attention for discussion.
The two state agencies. And after the Attorney General will preside over the two state agencies and ensure that the two agencies collaborate. But they are across purposes, and that for me is a problem.
Okay. Dr. Thea Champong, in a minute, concluding comments?
Yeah, so again, for me, my concluding comment, I don't believe what the AG is said this morning on the platform, given what we've seen in terms of the documentation and related matters. So we need to do more, but clearly it comes across to me that this would most likely become a police case.
Interesting. And as I read to you the CDD statement, they are also deeply concerned about the turn of events. And they say the president appears to want to exonerate targets of some of these investigations, and they are not getting to a conclusive end in those matters. They are asking the president to stop telling Ghanaians about being the government that is giving anti-corruption agencies the most money. They say that is nothing if you will not allow them to do the work and do it well. We'll take a break here. We'll return with the EC and also Imani explaining why they do not believe the EC when it says that it auctioned obsolete BVDs.